When it comes to our right to AR-15 semi-automatic firearms and magazines that hold more than 10 rounds, the ball is now in the Supreme Court's hands in the case of National Association for Gun Rights versus Naperville. That's the city of Naperville and the state of Illinois. Let's talk about what the Supreme Court might do coming up in this case and beyond. Hey folks, I'm Mark Smith, host of the Four Box Diner, proud American gunner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. Check that out. And if you're not following us on Twitter, please do so. Check us out at Four Boxes Diner. All right, folks. This video about this case involving AR-15s and magazines is to a large degree about procedure and what this means for our rights. And just keep this in mind before I lay out what I think the Supreme Court is looking to do. As you may recall from prior videos, there is a case before the Supreme Court involving the city of Naperville and the state of Illinois. But there's a parallel case, of course, involving several other litigants in the Seventh Circuit Court of Appeals. So what happened here, just as a quick reminder, you had two cases, or two sets of cases. One, the National Association for Gun Rights, that was in the Northern District of Illinois, which is basically the Chicago area. The lower court there denied the motion for an injunction. And an injunction is basically they were seeking an injunction that would have told the state, the court would have told the state, don't enforce the bans on AR-15s or on magazines because it's unconstitutional. The judge in the Chicagoland, in a terrible decision I've talked about in this videos before, denied that injunction request. The National Association for Gun Rights and Mr. Bevis took an emergency application to the Seventh Circuit Court of Appeals asking for them to enjoin the state law. The Seventh Circuit Court of Appeals said no. And then the National Association for Gun Rights took an emergency application or emergency appeal seeking the United States Supreme Court to enjoin the Illinois gun control laws on the grounds of violating the Second Amendment. And when that happened, usually those requests for emergency relief are just denied because they're considered just not going to happen because the Supreme Court historically really only wants to hear cases at the very end of the process after there's a final judgment so they have the full benefit of all the briefing and all the arguments and all the facts. But what's interesting here is that when the National Association for Gun Rights filed their emergency application, rather than just being dismissed out of hand and denied, Justice Barrett actually entered an order directing the defendants in the case, the state defendants, to file a response explaining why they think that these laws are somehow constitutional under the Second Amendment. The state then filed those briefs. In addition to those briefs, there was an amicus brief filed by attorneys Paul Clement and Aaron Murphy on behalf of the National Shooting Sports Foundation. And they filed that amicus brief because they're the ones, with other lawyers, of course, that are handling that parallel set of cases that I alluded to, which is a set of cases that's coming up through the system that started in not the Northern District of Illinois, which is Chicago, but in the Southern District of Illinois. And in the Southern District of Illinois, the attorneys for the gun rights plaintiffs, if you will, won an injunction in front of Federal District Court Judge Steve McGlynn, who found in a very powerful decision that obviously, because semi-automatic rifles, AR-15s, and these magazines that hold more than 10 rounds are commonly owned by Americans for lawful purposes, there's no debate about that. There was no evidence on the other side. That Judge McGlynn says under the prevailing and legal standard that the Supreme Court set forth in Heller, which is that if a weapon is in common use by Americans for lawful purposes, it's protected and cannot be banned. It cannot be banned under Heller. And Judge McGlynn applied that and enjoined the state law. So after Judge McGlynn entered the injunction enjoining Illinois' law, the state of Illinois took an emergency appeal seeking an emergency stay from the Seventh Circuit Court of Appeals. The Seventh Circuit Court of Appeals is the circuit that oversees all the federal district courts in Illinois, including the Northern District Courts and the Southern District Courts. Okay? And the Seventh Circuit Court of Appeals with a single judge, Judge Frank Easterbrook, who was absolutely 100% terrible on the Second Amendment in all respects. We've talked about him on this video before. Okay? On these videos before. He, immediately stayed Judge McGlynn's decision. Now, what's weird about that and this is helpful for us. Remember, I sometimes teach you that bad news in the short run can give rise to great news in the long run. Here is an example where that may be true when it comes to the U.S. Supreme Court. You see, when the state of Illinois took that emergency appeal from Judge McGlynn's order enjoining the gun laws in Illinois, the state of Illinois filed their emergency application for a stay of Judge McGlynn's order. Judge Easterbrook, who, as you know, is terrible on the Second Amendment, he entered a stay stopping the injunction of Judge McGlynn's from, continuing. Now, what is odd about that is, do you know what Judge Easterbrook did not, I repeat, did not have in front of him when he entered the stay preventing Judge McGlynn's injunction from going into effect? Judge Frank Easterbrook did not have any legal briefing supporting the injunction filed by the Second Amendment plaintiffs' attorneys. Did you hear what I just said? Judge Easterbrook entered a stay preventing Judge McGlynn's injunction from continuing without the benefit of having looked at the papers or any briefing or anything whatsoever from the Second Amendment plaintiffs' lawyers. In other words, he looked at one side, entered the stay, and did not get around to looking at any papers filed by the pro-Second Amendment lawyers because he didn't give them a chance to file any. And yet he entered that stay, an extraordinary relief, overriding Judge McGlynn's long, extensive, detailed opinion laid out after hearing everything from oral argument and major briefing and everything else. And Judge Easterbrook on the Seventh Circuit Court of Appeals quickly just snapped his fingers and stayed it. Well, that is not a good look, in my opinion, as someone who's done a lot of legal work all around America. Okay, it's not a good look when the judge appears to make a snap decision like that without hearing arguments on both sides, especially in a situation like this. So the reason why I talk about that case is the lawyers for the plaintiffs in that case involving, which is Barnett versus Rao, I believe. That's the case that came out of Judge McGlynn. That parallel set of case, the lawyers for that filed an amicus brief supporting the Second Amendment plaintiffs, specifically the National Association of Gun Rights, before the Supreme Court. So now where you are is the U.S. Supreme Court has a pending application from the National Association of Gun Rights asking that the Supreme Court enjoin on an emergency basis the Illinois gun laws involving AR-15s and magazines for the purposes of the pendency of the Seventh Circuit Court of Appeals, meaning while the Seventh Circuit Court of Appeals is going to preside over and make a decision on the merits of the gun bans in Illinois during that time period, which could last over a year. The question is whether or not the Illinois gun laws will be in effect so that you can't buy an AR-15 in Illinois because the gun laws are in effect, or will the Supreme Court enter an injunction that says during the pendency of the appeal process in front of the Seventh Circuit Court of Appeals, we are enjoining the Illinois gun laws so that people can continue to exercise their Second Amendment rights like they have since the beginning of time in Illinois. So that's what's really being fought about here in front of the Supreme Court is during the next 12 to 18 months when the Seventh Circuit Court of Appeals is going to hear robustly, hear oral argument, see the briefing, and make a decision on both, and this is the key, on both the National Association for Gun Rights Bevis versus Naperville case, and they will likely hear these things together, and the Barnett versus Rao case. One came out of the Northern District of Illinois, the other out of the Southern District of Illinois, but the Seventh Circuit Court of Appeals, because they're very similar, is going to probably hear them together in one kind of consolidated case. During the pendency of that, the question is whether or not these Illinois gun control laws will remain in effect and enforceable, which means you can go to jail if you violate them, or they'll be enjoined, which means they won't be in force at all. So what will the Supreme Court do with this now that I've just laid this out? Well, I think the Supreme Court is going to look at this and see that Judge Easterbrook, the way he handled himself, they're probably not going to be super excited about the way Judge Easterbrook handled this matter. But that may not be sufficient for the U.S. Supreme Court to get involved because, as I've explained to you before, the procedural posture of this case is not the kind of case where the Supreme Court usually gets involved with, because the Supreme Court likes to wait for a case to get to the very end, final judgment, everything is done, and then they weigh in, okay? They don't like to do things on what's known as interlocutory. That's interlocutory basis, which means in the middle of a case. They don't generally like to do that for a bunch of reasons. So that's what's really going on here. So you have sort of at the early part of a case involving the Second Amendment, a big fight over injunctions. The Supreme Court, as a general matter, would almost always say no to these things. But the fact that Justice Barrett actually asked for the defendant to submit briefing on this tells us that Justice Barrett, and likely the entire Supreme Court, is looking at this because they learned their lesson from the 10 plus years between the Heller decision in 2008 and the Bruen decision in 2022 about how lower courts and legislatures in many respects thumb their nose at the Second Amendment. And I don't think the Supreme Court is going to allow that to occur again. And just to give you a little big picture context before we drill down, and let me explain to you how I think the Supreme Court could rule in our favor. Before we drill down into that context, I want to remind you of one thing. And this is something I think the Supreme Court is likely going to be aware of. On the day that NYSRPA versus Bruen was decided, I believe there were 6 quote-unquote gun AR-15 bans / magazine bans, whatever you want to call them. There were approximately, I think there were 6 on the day Bruen was decided. Today, as part of a backlash, angry upsetness that the United States Supreme Court is requiring these states to actually follow the text of the Constitution and the text of the Second Amendment, there are now 4 additional states that have enacted quote-unquote assault weapon bans, including Illinois. So it seems to me that many states, especially these blue states where the Democrats control all organs of the government, are trying to rebel against the Supreme Court's decision in NYSRPA versus Bruen, which is what we're seeing. So I think the Supreme Court is likely aware of this. That doesn't necessarily mean they're going to step in and give this extraordinary relief, because it would be somewhat extraordinary. But one of the things going in our favor is the amicus brief of Paul Clement and Aaron Murphy to supplement the very strong law for the National Association for Gun Rights. I think it was very helpful that Paul Clement and Aaron Murphy weighed in on this. We've talked about this before because he really laid out how easy a case this is. So now that is kind of the context. Now, what do I think the Supreme Court should consider doing? If I were on the Supreme Court, I think what I would consider doing is along the lines of the following. Assuming the Supreme Court gets over their procedural posture concerns, meaning this is a case that's not fully adjudicated yet, it's just an interlocutory appeal. Assuming the Supreme Court feels comfortable getting around the procedural posture of this case, or not worrying about the procedural posture of this case, it's entirely up to them, it's their discretion, then I do think the Supreme Court could enter an injunctive relief and feel comfortable doing so. Because I think in this case, dealing with a ban on commonly owned firearms, this is an easy case, and this is not the sort of thing that requires additional briefing, additional litigation. Let me tell you why. There's 2 things that go into a deciding of a case, right? There's the law. What is the law that you apply? And then you apply the law to the facts. Here, the law is clear and the facts are undisputed. And what do I mean by that? It is crystal clear that the governing law in this case, dealing with an arms ban, is the Heller decision of that set forth the legal standard of in common use, which is that if an arm is in common use by Americans for lawful purposes, it cannot be banned, period, full stop. That is the legal standard. Now, that may not be, by the way, the only ways to protect arms. But we don't have to worry about other arms and other things right now. Right now, we have to laser focus on winning at the Supreme Court level, as I see it, that bans of semi-automatic firearms such as AR-15s and bans on magazines that hold more than 10 rounds are unconstitutional under the Second Amendment because they're in common use by Americans for lawful purposes. So the law requires no additional development because it's just the Supreme Court precedent of Heller. Apply it, it's over. And you can throw in, of course, the related precedent of Bruen that kind of elaborates on Heller a little bit, but it's all the same thing. It's the in common use test. So there's no required development of the law. It's done. So the question is, does there need to be any additional development of the facts? Does there need to be any discovery of the parties? Does there need to be any additional research or investigations of any of these things? The answer is no. Because the only question presented is the following. Are the types of firearms, meaning semi-automatic firearms, that are banned by Illinois, are they in common use by Americans for lawful purposes, yes or no? The answer is obviously yes. There's no dispute. They're not. In fact, I would argue these things have been in common use as a matter of law since 1994 at least, when the United States Supreme Court decided Staples versus United States, which is why I always tell you that if you are looking at a gun ban case briefing by lawyers and they don't talk about Staples versus the United States, which said that semi-automatic firearms are commonly owned by Americans for innocent lawful purposes, 1994, mind you, well, then, you're looking at a brief, in my view, which should be considered incomplete, because you have to address Staples if you're dealing with a semi-automatic rifle ban in some way. So here you have the law is settled with Heller, and the question of fact is, are these firearms in common use for lawful purposes? And the answer is undeniably yes, because the lawyers for the National Association for Gun Rights and Paul Clement and Aaron Murphy, they've obviously submitted ample evidence that there's tens of millions of AR-15 style semi-automatic firearms in America, and there are probably hundreds of millions of magazines of Homeward 10 rounds in America. And even if you want to, and even the state of Illinois agrees that there are literally millions and millions of people in America that own these firearms. And of course, we know that the ATF has admitted that the most popular rifle in the United States is the AR-15. I believe I'm the one that flagged that first in a video back in 2022 in the spring. And of course, we know that there's things like the Washington Post survey that says there's millions of AR-15s in their most popular rifle yet again. So the point is, there's no dispute that AR-15s and magazines of more than 10 rounds are in common use by Americans for lawful purposes. And there's no dispute. So here you have a situation where the law is set and the facts are not disputed, and the defendants in these cases, the city of Naperville and the state of Illinois, are not even really trying to argue that these are not in common use. They're trying to argue that the law is somehow different. It's not going to work because the Supreme Court knows what the law is, because they're the ones that helped structure it, because they wrote the Heller decisions. So the bottom line is, this is not a case that requires like 3 more years of discovery and investigation, because everything the Supreme Court needs to know is already in front of them, both on the law and the facts. And now it seems to me they can enter an injunction that will be binding on the Seventh Circuit while the Seventh Circuit takes the next year or 18 months to decide the case. Now, let's talk a little bit more about some other things involving this. Now, let's talk about the purpose of an injunction. Historically, the purpose of an injunction is to maintain the status quo during the duration of a case if there's a big dispute about whether something's allowed or not allowed. So if you think about this here, since the beginning of time in the state of Illinois, Americans could purchase these magazines and these rifles with, just following the basic law. They weren't banned or anything. The status quo, which has been going on since the beginning of the country, or the beginning of Illinois within the country, right, has been you can buy these arms. Now, as of 2023, the state has passed laws that have changed that status quo, and you'll see why this is important. The state of Illinois has passed laws that have changed the status quo to something more radical, right? They're changing the status quo from you could buy these arms and you could buy these magazines and the like, right? These firearms and the magazines are arms too, of course, to you can't buy them. So the change in the status quo is toward gun control law. So what the Supreme Court here is being asked to do is to enjoin the gun control law. So the status quo that has been the case, which has been the status in the state of Illinois for over 100 years, right? Because Illinois wasn't one of the first 13 colonies. That's why I'm fudging the date here. But the point is that the status quo in Illinois, since it became a state, and even before, was you could buy these weapons. So an injunction by the Supreme Court here enjoining the law during the duration of the appeal in the Seventh Circuit, which again will take 12 to 18 months, is really preserving the status quo. It's not changing the status quo, it's preserving the status quo that has been the law, has been the status in Illinois for a long period of time. It is the Illinois legislature that is trying to change the status quo by enacting these, to me, clearly unconstitutional gun laws. All right, so that's a reason why I think the Supreme Court could intervene here, because again, the law is clear, the facts are clear, there's no dispute on either, and they're not actually changing the status quo with enjoining the state of Illinois. They're actually maintaining it. And again, as a general matter for you litigators out there, you all know it's a lot easier to get an injunction if you're trying to maintain the status quo as opposed to trying to change the status quo, which is much harder and a higher burden for those litigators out there. You know what I'm talking about. And the last point I want to make is if you look at the Caetano versus Massachusetts case, this is very important. Now, Caetano, if you recall, was after a woman who had a stun gun was convicted in court of a crime of possessing a stun gun. She took an appeal to the Massachusetts State Supreme Court. That appeal was denied, meaning her criminal conviction continued. They then sought certiorari to the United States Supreme Court on the grounds that stun guns are protected arms under the Second Amendment's right of the people to keep and bear arms. Now, here's what's interesting. This is what gives me some hope that we can prevail on this injunctive relief. So to sum up, to get an injunction in American law, you generally have to show that you're likely going to win on the merits at the end of the case. If you don't get an injunction, there will be irreparable harm to someone. And the balance of the equities are basically in your favor, okay? Here, all three elements are satisfied. Number one is, it's pretty clear that these gun bans are unconstitutional because of clear legal precedent by the Supreme Court and the facts on the ground that really cannot be disputed in terms of the common use of these firearms and these magazines. So on the merits, it appears that the plaintiffs will win this case. The irreparable harm is clear because it's basic black letter constitutional law that even a single day of having your constitutional rights violated is viewed as irreparable harm. Irreparable harm. So that seems pretty much established here. And the last thing is the balance of the equities / what's in the public interest. The law also says that governments, including the city of Naperville here, which is a government, and the state of Illinois, which is a government, governments have no interest whatsoever in allowing or causing the violation of constitutional rights of Americans. So there is no interest in favor of violating the Second Amendment. So again, on the merits, we're likely to win. Irreparable harm, yes, Americans that want to be able to buy these guns in Illinois will be denied that. That's denying them the ability to acquire firearms for, among other things, self-defense and other lawful purposes. That is a violation of the Second Amendment. That is irreparable harm because it's irreparable harm to violate one's constitutional rights. And again, there is no interest on the other side because the court has repeatedly says that states have no interest at all, and no interest may be considered in favor of the states to the extent someone's constitutional rights are being violated, which they would be here. So, okay? So again, at the end of the day, if we lose this emergency appeal, it will almost certainly be because of the procedural posture and not because of the Supreme Court's particular view on the substance of the Second Amendment. And that's the issue here. Will the Supreme Court, just apply their usual procedural rules and deny the emergency application as not properly ripe? Or will they kind of say, look, this is something that is extraordinary and it's so wrong, we're going to step in and either enter an injunction or we're going to signal in some way with a statement that there's a problem here and we want this fixed by the Seventh Circuit Court of Appeals. One does not know what will happen, but that is kind of how this whole thing is teed up, and that's where we are. So, okay, I hope you learned a little bit something here today about some of this geeky procedural process stuff that's affecting all of our rights to keep and bear arms. And again, if you haven't subscribed to the Four Boxes Diner or followed us on Twitter at Four Boxes Diner, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.